Hey, good morning, everyone. Welcome back to Law and Legitimacy. That's right, we were gone for a couple days, and the world continued to spin on its axis. But based on the number of private notes I got, you did miss us. We missed you too. I mean, Friday, Mike had an issue where he had commitments and you had to be there first thing in the morning. I'm not to be trusted with the keys to the car alone, apparently. And yesterday, I had to be in court early for whatever reason, I don't know, because the prosecutor lost the file. We had to find somebody to talk about the case, and then we just continue it. What happens when the defendant doesn't show up for the court? Rearrest. What happens when the prosecution can't find the file and isn't ready? Would you like another date? Yeah, I'd like another date. How about forever, never? And give me a nollie and just drop the case. But that's not the way the world works. And I can accept that. Not. So I'm back in the swamp, back in DC for what I am hoping will be my last appearance here for 2023. And I know it's only September, but I've spent about 6 months down here, or so it feels, maybe five and a half this year. That's enough for this Northeasterner. Today I'm here on the case of United States of America versus Owen Shroyer. You may have seen some reference to this case over the weekend. It blew up. Tim Pool did a segment on it. Joe Rogan's been interested. Tucker Carlson, I don't think, has commented on it publicly, but I know he's been in touch and he's following the case. And of course, Alex Jones has had plenty to say about it. Tucker is the afternoon personality on InfoWars. He does the War Room. Young guy, 30s. He's been at it for about 10 years, and he has become a reliable voice on the right. Tucker was present on the Capitol grounds on January 6, 2021, and he marched with folks with Alex Jones and others from InfoWars, and he entered Capitol grounds. And they approached the Capitol. When they got to the east steps of the Capitol, they asked officers, hey, maybe we can help calm the crowd down. Officers acquiesced to their going onto the Capitol steps. And there's Alex Jones with a bullhorn telling people to stand down. Trying to direct them elsewhere. Don't enter the Capitol. Don't give the left what they want, he was saying. Now, of course, the very next day, the Wall Street Journal reported that Jones was inciting the crowd. I called the Journal and I said, hello, I've got a videotape here. He wasn't doing otherwise. They said, we were standing right there. We heard that. I sent them the videotape and they said, whoops, we bad. And the Wall Street Journal printed a correction. Why do I tell that bit about the Journal? Well, because, obviously perceptions are biased and you see what you want to see. And in this case, the government has chosen, the January 6 cases, to see an insurrection, to see a direct threat to democracy. And they continue to arrest people, and they continue to seek imprisonment of everyone that, not to seek imprisonment of everyone, that's an overstatement, but they continue to arrest everybody who was present on the grounds. Owen was present on the grounds, and he has pled guilty to one misdemeanor count of entering or remaining in or on a restricted area. It's a misdemeanor carrying up to 1 year in jail. The federal prosecutors this past week filed a sentencing memorandum in which they announced they think he should go to jail for 120 days because, after all, listen to what he said. 1776, down with tyranny, death to tyrants. In other words, a series of utterances that he urged on his own megaphone as they walked from the ellipse where they'd listened to Donald Trump to the Capitol. Our position has been, wait a minute, that's speech. And you cannot put a person in jail for what they've said, not in these United States of America, at least not yet. The government's response has been and will be, well, this is relevant offense conduct. Under federal sentencing law, a court is entitled to consider conduct that sheds light on the offense itself. Our position is not so fast. This is speech. And speech is sacrosanct, especially political speech. Unlike the Proud Boys case, where the court held that the speech they made, even the utterances they made about January 6th prior to the riot could shed light on an insurrectionist intent, that is, the intent to use force against the authority of the United States government, a seditious intent. We don't have that here. Mr. Shroyer's speech is not a predicate to some act. It doesn't explain his state of mind in standing on the Capitol grounds. And so there'll be argument this morning about whether the court should even consider his speech or not. The government will say, well, wait, Mr. Shroyer had previously been given a deferred prosecution agreement because he interrupted an impeachment proceeding that Larry Nadler was holding back in 2019. He walked up to the dais and basically accused Nadler of himself needing impeachment. He was escorted from the room, charged, and in a separate court, in a separate set of proceedings, we entered a deal. If he was a good boy, minded his P's and Q's, the case would be dismissed because, after all, this was protected speech, if not in a public forum, but at least in an understandable and public place. That deferred prosecution agreement called for him not to step foot on Capitol grounds, and he did on January 6th, and hence the guilty plea. Owen has not been a cooperator with the feds. He's not flipped on anybody, but he has been cooperative with the federal government. They didn't have to indict him. We didn't challenge the arrest decision. He had a right to request an indictment. We didn't do that. We waived indictment. The feds asked for permission to see his phones. We evaluated the request and ultimately gave them his phones without a warrant. After they dumped the data from his phones, looking vainly, I suspect, for proof that Alex Jones and others at InfoWars organized the sedition attempt, we sat down for an interview with the FBI, and Owen answered their questions truthfully. The interview lasted but a couple hours. No one has suggested he's been anything but truthful. He's been entirely compliant with the conditions of pretrial release for the couple of years that he has been under charge, that he's been charged. And from our perspective, he's done everything that's required of him. The feds then contend, well, wait, he's shown no respect for the law. He was supposed to do 32 hours of community service, and he hasn't done it as part of the deferred prosecution agreement. I guess they weren't talking to one another, because in a memo we filed with the court, we included emails that we sent to the federal prosecutor handling the Nadler case that demonstrated that Owen did his community service. We sent a request to them in February of 2021, a month after January 6th, saying, here's proof that Owen did his 32 hours. We'd like you to dismiss the case as agreed. We got a note back, oh, no, we're now investigating Owen for January 6th. And oh, by the way, you miscalculated, he owes 2 hours. So he went out and did 2 more hours of community service. For Uncle Sam to file in court papers that are public, that Owen, welched on his obligation is simply wrong. So we will appear before Judge Tim Kelly, the same judge who sentenced the Proud Boys and who tried the Proud Boys case at 10 a.m., and argue that Mr. Shroyer has done his time. He's been under federal supervision for 2 years. He should not be required to go to jail, and frankly should not be required to undergo any more supervision. That we're unlikely to get everything we ask for. The judge could easily decide to put Mr. Shroyer in jail. If so, we will seek an appeal. The manner in which the government proceeded in this case represents, as I wrote in a sentencing memo, a new low watermark for the January 6th prosecutions. They took quintessential political speech and used it as relevant offense conduct to ask for prison for a man who pled guilty to a misdemeanor. There just seems like there's something wrong with that. And so stay tuned. I'm sure it'll be all over the news this afternoon. Owen Shroyer will be sentenced to 10. A quick transition on the topic of sentencing. I want to just pivot quickly to trial tax discussions. I filed a notice in open court on the public docket last week indicating that the plea offers made to the Proud Boys in October of 2022 were in the 5 to 12 year range. And look what happened. They got 10 to 22 years. The government seeking 30 to 33. Why I asked if it was justice in October for 5 years to be imposed, did it suddenly become required that so much more be imposed later after they had gone to trial? And I suggested we might raise on appeal the issue of a trial tax. A lot of people have pushed back and angrily pushed back.
Well, it's not a lot. It's just, the amount of people that push back on X in your direct replies makes it seem like many more people feel the same way that you do than actually do, because I was monitoring a lot of that and using my own discretion not to call people dolts every chance I got.
But the counter argument, I mean, so the trial tax argument is that when you're made a plea offer of X years and you go to trial and you get X plus, whether it's 2, 3, 4, 5, 10, 100 years, there's something wrong with the system. That in effect you've been punished. The penalty has increased because you've gone to trial. The counter argument is no, it's not a trial tax; it's a discount. The government is saying, you're going to get hurt worse, and we'll offer you some leniency if you plead and spare us the ordeal and expense and aggravation of trial. That might work in the state system, but it doesn't work in the federal system. In the federal system, there are sentencing guidelines, and the guidelines bake in acceptance of responsibility. You get 3 points in a major felony for acceptance of responsibility, which is expressly acknowledges entering a prompt guilty plea. So I simply part company with those who view the trial tax as non-existent, and that it's a discount. In particular, in the Proud Boys case, nothing in the plea agreement suggested these men should be designated as terrorists. It was only after they went to trial that the government sought a terror enhancement. And from where I sit, that's just flat out wrong.
Yeah, it's a little ridiculous, right? That's not. But you've talked in previous. I think we actually did a long form podcast episode a long time ago, Norm, where you discussed a concept known as the last best offer under seal. Yep. Do you mind, because I want to explore the practical implications of what we would regard as the trial tax and what mechanisms we might be able to use in the future if this is something that gains some sort of populist support for policy change?
So in cases without sentencing guidelines, plea negotiations are usually conducted in chambers or in the presence of a judge, or simply in discussions between a lawyer and the prosecution, a defense lawyer and the prosecution. If the offer is rejected, then the case goes to trial. The last best offer is usually far less than what is imposed if a person loses a trial, and that is rarely placed on the record in any context for an appellate court to review. So we've adopted a practice in many cases, in state courts at least, of filing the last best offer, if necessary, under seal so the sentencing judge doesn't know it, so that we can say to the appellate court later, if it was justice then, it is presumptively justice at the end of trial, and the state should have to justify why a penalty greater than what they thought was fair, just, and reasonable at the plea stage is fair, just, and reasonable now. And the court should evaluate the state's reasons to discern and ascertain and assure that there is no mixed motive there, no desire to punish a defendant for going to trial, no desire to send a message to other defendants, don't mess with Uncle Sam, or don't mess with Sister State, or we're going to take your scalp if you lose trial. And so the last best offer concept basically says prosecutors have a duty to do justice. When they offer to plead a case on certain terms, those terms are terms they believe were fair, just, and reasonable at the time they were offered. If they were fair, just, and reasonable then, how is it that going to trial makes the offer worse? What becomes fair, just, and reasonable? What is unfair, unjust, and unreasonable other than the imposition of a trial tax? And as far as I'm concerned, that argument seals the day. There is no notion. The only time in which the discount argument works is when there is so-called charge bargaining. If this happens often in Connecticut, if you murder, for example, murder is a mandatory minimum of 25 years, a maximum of 60 years. Manslaughter is less. Let's talk about, just to make it simple, manslaughter without a firearm is a maximum of 20, and a minimum, I think, of 2. I can't recall the minimum actually. So if you can charge bargain in a murder context, what you can do is get rid of the mandatory minimum of murder. And you still have a homicide, the unlawful taking of a human life, but you're able to do so much more. But the state must agree to come off the murder charge. And so in that context, the discount argument works because you're getting a discount off the mandatory minimum. But when there is no upper limit discount, you can't say that the discount analogy works in Proud Boys case, or in a case where the government adds penalties after the sentence, or after the verdict, I should say. So that's the trial tax. We'll see what happens.
So 2 things. Dawn, good morning, and my apologies, Dawn, for what my fantasy team did to yours this weekend. I hope you can forgive me. But Dawn says that it sounds like Owen got a plea deal tax. They mess with you either way because they are evil.
Well, it sure feels that way to me. Not that they're evil, but that they've been less than scrupulous. I mean, there was an understanding, and no pun intended here, Proud Boys followers, an implicit understanding between the government and I that in exchange for Owen's cooperation with respect to the phones and so forth, they wouldn't be looking for a scalp on sentencing day, and now they are. And I've called them on it. They recall it differently. There was no writing, so that's bad. Yeah, and while we're on the topic of apologies, Luttrell, look, I tried to give you the game last night. I sent a message over to Josh Allen. Hey, throw some interceptions, like 3. Hey, Allen, fumble the ball on the pivotal drive of the game. Yeah, hey, toss the game by defense by letting letting them return a punt in overtime for a touchdown. I did everything I could, Luttrell. I did everything I could to give you the game, but the objectors won, and for that I am grateful.
I guess we're all counting down to week 6 when you and I butt heads then, huh, Norm?
No, I'm not counting down for it. I'm prepared. I suspect you're probably fortifying yourself for the inevitable, which will be a defeat. And I wish you well in your efforts to keep up stiff upper lip.
Oh, good Lord. So one other thing before we move on, Jackson Barrett says InfoWars had a permit to hold a rally at Lot 8 on the northeast corner of the Capitol grounds. It seems like entrapment. I wanted to bring that back just so that we didn't leave that languishing in the Rumble chat where we have a lot of people this morning. So good morning. But what do you make of that, Norm, and how has that played a factor, if at all, in Owen's plea?
No one else in the InfoWars group has been prosecuted, and that may well be the reason. But as to Owen, he had the deferred prosecution agreement, and that does cloud his situation. The deferred prosecution agreement again arose from his interference with Congress during an impeachment hearing conducted by the House Judiciary Committee. He was obliged not to step foot on Capitol grounds or a restricted area while that deferred prosecution agreement was in effect. And he broke it. I mean, and that's why he entered the guilty plea. Yeah, I'm not happy about it, but that's life.
And the follow up to this, because Jackson, I think you're on a nice thread here. He follows up by saying everything in federal quote unquote justice has become a gray mail issue, which I love that phrase. I haven't really seen it used very much, but I intuitively understand what it means. A gray mail issue where the government wants to hide information and taking them to trial threatens that.
Well, that it may well be. I mean, so I started something. I alert everybody to do what you will with it. But we started a Freedom Fund page on GoSendMe. I think it's called the Freedom Fund, where I'm asking for contributions that will be devoted to litigation efforts involving freedom of speech. And the first effort is going to be to try to make public information about confidential human sources in the FBI and their surveillance and infiltration of domestic groups, typically conservative domestic groups. I learned a lot in the Proud Boys case about that. I'm ordered to keep it confidential by the judge. Much of what I learned took place in sealed proceedings. And so we're looking for contributors to finance a litigation effort wherein we will file an FOI request asking for that information to be provided to us. When it's denied, we'll take it to court and seek to compel disclosure. This fight, in my view, is as significant as what Frank Church did with COINTELPRO, the counterintelligence program that intelligence agencies were involved in against the left and Martin Luther King in the 1970s. I know to a moral certainty that the FBI has a massive program involved in domestic surveillance. I know it because I saw it with my own eyes, and then I was ordered to keep my mouth shut about it. I don't intend to be silent forever, but I do intend to respect the judge's orders, and we're looking for your support in efforts to litigate that claim publicly. Hey, what in the world's going on in New Mexico? I think I told you. Yeah, I think tune into the world, babe. This is the United States of America. We warned you in our January 1st show about some of the things we'd be keeping an eye on. And one of the things we predicted is that there would be an effort to extend the emergency powers that governors got used to using during COVID to address other so-called public health crises, including gun violence. And there she is.
Yeah, so when I first read this, I think this would have been
Tell us what it is.
So the news was breaking Friday night. I'm trying to time it. Was this Friday night or Saturday night that this stuff was? I believe
it was Friday night.
Yeah, and that's so. First and foremost, anytime an executive makes some sort of sweeping suspension, and they do it on a Friday, you can intuitively understand that that is done purposefully, willfully, to avoid immense scrutiny on the front end, at least having 48 hours thereafter for that to go into effect without the courts being open, for there to be a challenge or an injunction issued blocking enforcement of that action. So first and foremost, the New Mexico governor, this was not executive authority wielded across the whole state. I think a lot of people perhaps thought that the governor was doing this to suspend the Second Amendment across the entire state of New Mexico. That is not it. It was specific portions of, I believe, Albuquerque. Norm, is that correct? The city of
Albuquerque and then an adjoining county. So apparently in recent days, there have been a number of horrible shootings. Young people, an 11-year-old boy on his way home from Little League practice or football practice or something, shot dead. Another child shot dead. Senseless gun violence, of which we have become all too accustomed in this country. And so the governor's response was to say there's going to be a 30-day moratorium on concealed and open carry in these two counties as a way of addressing gun violence, leaving those who carry weapons to protect themselves against the violence in a failed state situation powerless to protect themselves.
Yeah, and I think that all of the major accounts on social media, sort of on the populist right, certainly took this immediately and ran with it and came to generally the correct conclusion on an obvious overreach of executive power and the unconstitutional nature of such a move. And again, she's declaring a public health crisis. And if you listen to her,
she doubled down.
But I think what you were redeemed a little bit by, Norm, or not that you were redeemed, but what was redeeming in your perspective was that there were popular voices on the left that also seemed to be trying to reel this in and come to some sort of sensible conclusion about the nature of how aggressive and out of line this ultimately was. But I've got to admit that this isn't necessarily surprising that she has doubled down. To me, I think that this is part of the playbook that we've seen, right? If you are making any decision, if you're going to say, Norm, if one is going to assert that there is a public health crisis, and on the back of that public health crisis to mandate some sort of suspension of civil liberties, just because one receives pushback doesn't necessarily mean that you have the ability, or at least to have any of your credibility intact thereafter, to just say that there isn't a public health crisis, right? If your nexus to suspension of the Second Amendment, for example, is a public health crisis on the back of gun violence, then it appears as though you're limited in your ability to, I guess, change your tune or back off, because the question is then, well, is there a public health crisis or not, right? And so she doesn't have a choice. I think she's an idiot. I think that this is common, where we are. The crisis of incompetency in America is looming quite large at this point. And this is a perfect example of an incompetent governor who has somehow been elected to this position, that she would be moved to make such a ridiculous move.
You say it's ridiculous, but the CDC, the Center for Disease Control, has been calling gun violence a public health crisis for a long time. So is she ridiculous, or is she of a type? Is she of a type that thinks that the state, look, I had some really scary thoughts over the weekend. I was thinking about fantasy football for the most part. But aside from that, we've talked before about Mary Midgley's work. She's a British philosopher who recently died. And she wrote famously that, the social contract theory that Locke evoked and that talked about natural rights and liberty and limited government by consent, that was a reaction to the divine right of kings theory, that all power flowed from God and we owed absolutely obedience. And so Locke, in the first treatise of government, ridiculed Robert Filmer's Patriarcha, a book that said all power flows from God directly. And, Locke had a lot to say about it, and he exposed the ideas as ridiculous. His counterweight was the state of nature, government, social contract, individual consent, limitations on government, the right to rebel, the right to take government back. And the framers in our country were largely influenced by Locke, and discussions about the Bill of Rights and their interpretation even today are largely influenced by Locke. But here's the scary thought. What if we've outgrown the Bill of Rights? What if the pressing necessities of our time, at least in the eyes of many Americans, are such that the Bill of Rights is no longer a good fit? What if the Bill of Rights today and theories of natural rights, social contract, and government by consent stand in relation to the felt necessity of our times in the same way that the divine right of kings did at Locke's time? I would suggest to you that there's a new intellectual ferment brewing, and that sooner or later somebody's going to write a massive tome about AI and the need for a global community that's going to seek to recast political philosophy in ways that move it away from consent. Because let's face it, the social contract theory never solved the chicken and the egg problem. Who raised the first child that consented to be governed? What came first, the chicken or the egg, the village or the individual? Norman Mailer, at the end of Harlot's Ghost, did something, a tremendous stroke of brilliance. He said, maybe God hid his tracks from us. Maybe when he created the world, he created it in such a way that it was encoded that we would be misdirected away from him and toward a theory of evolution. Maybe he created the world ex nihilo, and he created 40-year-olds in the world, 6-year-olds in the world. And, Mailer's brilliant stroke avoided the chicken and the egg problem that is incident to that. But I digress. So I look, I want to say more about this later, and I know time is running short here.
Well,
but with respect to the New Mexico governor, there are a lot of people who think like she does, and they don't want the Bill of Rights.
You're using a very generous definition of the word "think," but I will allow it.
But they do. I mean, look at the World Economic Forum. Look at Schwab. Look at people who tend to think that consent is not something we should give freely. There's a fascinating new book, Mike, that I'm working my way through on Kindle right now, and it's called "The End of Reality." How 4 billionaires, and it's written. Of course, I can't get it on my screen here. It's written by Jonathan Taplin, how 4 billionaires are selling a fantasy future of the metaverse, Mars, and crypto. And basically the claim is that the big tech world is trying to get us in a position where we're habituated to obedience. We're going to live in the metaverse, we're going to use cryptocurrency, and we're going to be paid a universal basic income tax to basically sit home and twiddle our thumbs while the world is operated at scale by AI. And there'll be very few productive people because we won't need them. And so it'll be Aldous Huxley's Brave New World rather than Soma. We'll have our headsets on and we will play war games with one another to find significance while the masters of the universe control things that we don't actually see or smell or control. Lou John Grisham's move is consistent with that, in my view, and there are plenty of people who are thinking it through. I think you need to be careful about this stuff.
Well, so I put this post from @presentwitness_ on X. This post has lived rent free in my head for however many days, since 6 days since it was posted, and I'm not exaggerating that. I feel like I'm coming back to it every several hours of the last week or so now since I saw this. And I think I actually said, I think I quote tweeted this on my personal account and said something similar. But the post reads, "In order for millennials to live like boomers, they would have to literally enslave the Zoomers." And I put this on the screen just specifically to relate to, Norm, your point about how there are a number of people who resonate with the governor's decision here and her line of thinking and reasoning, and this emerging sense of the necessity of safety that comes from this paternalistic, ubiquitous force that is the government, right? And some I guess, attribution of benevolence to that force, that everything that ubiquitous force does is for the greater good, right? It's this sort of Voltaire's Candide, if you will, brought into the modern era. Everything is for the best, right? Just attributing this sort of attributing our sovereignty to something other than
Ourselves.
Yeah, and there is a wild narcissism to that. I think that maybe we've discussed that before, but for one to feel so insanely drawn to this notion that they need to be protected at all costs over their ability to make decisions on their own and to provide for their own safety is funny. I guess, to put it tritely, funny to me. But I come back to this tweet or this X post. I'm trying to get the lingo right, because it seems to me that Zoomers are being primed for this sort of relationship with authority. And these sorts of issues, when a governor puts something out there like this, and then you've got these cringe TikTok influencers just reciting political talking points that push their viewers into this direction, it really does seem to me that Zoomers are being programmed to be robots. Right.
Well, and look at
to be slaves.
Look at the robot in chief, David Hogg, whose claim to fame is surviving a mass shooting in Florida, and now he's the sort of Greta Thunberg of firearms. He's got an answer for everything, and he's a cheerleader for the unctuous. David Hogg and Greta Thunberg should get married and then populate an island with unctuous idiots, and then let that island detach itself from the rest of civilization. Because I don't want to be told how to live. I don't want to be told what's in my interest, what's good for me, by a couple of kids who haven't even lived yet. In Thunberg's case, her claim to fame is autism and the ability to focus on one thing and one thing only. In Hogg, he survived gun violence and has declared himself a saint and an oracle. Not.
Well, Hans PK over on Rumble says New Mexico had some of the longest lasting, most reaching COVID restrictions through governor emergency powers. And so I guess this tracks. Hans, thank you for that insight there. And I think I've actually hit a little bit of a nerve with this post talking about. I mean, this is a compliment to boomers. This is, to live like boomers. Millennials would have to literally enslave Zoomers. The only connection I'm making is that the wildest part of this is not that there's a disparity in the way of life between the generations. It's that I believe that Zoomers are actually closer to being enslaved than we want to explicitly acknowledge. That's my opinion, but that's also what I'm seeing. And when we see things like this that are given cover by young people, you do need to begin asking yourselves, with a hive mind interconnected with the algorithms that Norm doesn't think has anything to do with rewiring of our brains and the collective consciousness, and doesn't like Vivek Ramaswamy's position on limiting the use of social media to 16-year-old and older, which we will get to. This is something that speaks to me, and it will continue to speak to me, and I will continue to try and pull out these propositions and insights that I think flow from it. But there's something captured in this post that we need to I think, center around.
We're back. We were gone for 2 days. We're back now, Mike. I got to do a hard stop today because I'm due in court where I'm going to be meeting with the Honorable Timothy J. Kelly in what I hope will be my last sentencing before him. And once that sentencing is over, will I ever be relieved that I don't have to worry about what he thinks of me, and I can say what I think about what really happened in the Proud Boys case. So stay tuned. We will be back tomorrow, we hope. And we're working on the idea of premium content. We're likely to move our law school project over there. Those of you who purchased the textbook, the Paulson textbook on con law, we've gone through 2 assignments and it will soon do a 3rd. But we may move it off the general site because it takes a little more time to develop. We'll have more to report on that later in the week. Mike and I are noodling it and seeing what's possible. Mike, so thank you for coming back. Thank you for listening. Go on over to Give, Send, Go. Take a look at the Freedom Fund. If you think it's worth $5-10, kick something in. If you think it's worth $1 million, I promise to kick back to Pat an Angry Dog if we get $1 million contribution. But the point is, it's your constitution, it's your government, it's your world. If you don't fight to retain some piece of it, it will be taken for you. And right now, the courts are open. The Freedom Fund is dedicated to trying to find out more about, in part, the first fight that we intend to pick. Is with respect to the FBI's use of confidential informants to surveil domestic groups. Those groups are largely conservative now. There's a war on. And, on that and let me say this last piece. But folks, take a look at Alex Jones on InfoWars. He gets a bad rap. He's the Sandy Hook man. That's just a little piece, a little sliver of all that he's done. I think he'd do it differently if he could do it again now. But when it comes to talking about globalism, the deep state, and those aggregate forces that are seeking to undermine your sense of efficacy in your own community, Alex Jones was right. Take a look at him.
Well, thank you everybody for being here. Norm, I think we will continue to work on how to consolidate a lot of the things that we've got going on. For those of you that don't want to be surprised on the mornings that we don't have a stream Monday through Friday, do just go and join us via Locals. It doesn't cost anything to join us via Locals, but until we've got a master email list that will email you directly. I make sure to say whenever we don't have a stream coming up that morning, I make sure to ensure that goes to everybody's email inboxes that they designate on sign up. So go to Locals, lawandlegitimacy.locals.com. Join us there. You'll get all the news that we have. We don't really regularly post the streams there because it's somewhat redundant. But you can find us here on Rumble Video, YouTube Live, and on X at LawPod Daily. Do follow us at LawPod Daily. And if you don't join us via video and you like to catch us sort of in the car or in transit, walking around, running, you can find us on Apple Podcasts, Google, Spotify, Overcast, Audible, etc. So give us 5 stars. That means a lot to us. And perhaps leave a nice comment. But if you don't want to leave a nice comment, just leave us alone. Norm, go get them. I'll see you guys tomorrow.
And remember, Mike, it's 6 weeks from now. You've got a date with destiny. The objectors are coming into town, and we're going to clean your clock.
Yeah, just work those waiver wires, Norm. Learn to work those waiver wires. You're going to
have to. What wire?
See you later.
Bye.